Most Americans hear about immigration courts and instinctively treat what happens there as a political controversy. One side says the government is enforcing the law more aggressively. The other says fairness is being undermined. But that framing, honestly, misses the deeper point. What we're looking at isn't simply a disagreement over policy. It's what happens when adjudication is placed inside a structure that was never designed to produce independent judgment in the first place. Immigration courts sound like courts. Judges wear robes, hearings are held, decisions are issued. But structurally, they're not courts in the constitutional sense. They're administrative bodies housed inside the Department of Justice. The same executive branch that sets immigration enforcement policy also employs, evaluates, and can remove the people deciding individual cases. That single design choice determines everything that follows. The Constitution took the opposite approach for a reason. It assumed that if those who decide cases are dependent on those who want particular outcomes, the decisions will eventually reflect those pressures. So it removed the leverage. Federal judges cannot be fired for their rulings, their pay cannot be reduced, their decisions can be reversed, but only by other courts applying law, not by supervisors enforcing policy. That isn't an ethical aspiration, it's a structural barrier against influence. Now, consider how immigration courts actually operate in practice. Judges' decisions are tracked and compared, including how often they grant relief like asylum. Supervisors within the Department of Justice can review those patterns. Internal directives can signal that certain outcomes, such as granting release from detention or approving claims, are disfavored. Judges may be required to justify decisions that go against those expectations. At the same time, judges who are perceived as out of alignment can be removed, while new judges are hired with backgrounds more consistent with enforcement priorities. None of this requires an explicit order to rule this way. The structure does the work. Once adjudicators are employees of the same entity pursuing a policy goal, a self-reinforcing cycle emerges. The policy sets expectations. Those expectations shape decisions. Decisions are measured against the policy. Judges who align are retained. Judges who do not are replaced. Over time, the system produces outcomes consistent with its governing objective, not because every individual intends to abandon fairness, but because honestly, the incentives leave little room to do otherwise. You can see the effects in how outcomes begin to converge across the system. Relief that was once granted at varying rates becomes consistently rare. Detention becomes more common, not necessarily because each individual case warrants it, but because the system has shifted toward default denial. People held in detention for months or even years begin to abandon their claims simply to regain their freedom, even when they might otherwise have continued. The number of completed cases increases, and backlogs shrink, not because each case has been carefully adjudicated on its merits, but because the system has become more efficient at producing final removal orders. That efficiency is often presented as a success, and from a policy standpoint it may be, but it comes at a structural cost. The individual case, the core unit of due process, becomes secondary to system-wide output. The question shifts from what does the law require in this case, to how does this case fit within the broader enforcement objective? That shift is not the result of bad actors, it is the result of design. In a constitutional court, the triad is fixed. The purpose is neutral adjudication. The mechanism is independence from political control. The application is the resolution of individual cases under law, subject to external review. Each part reinforces the others. Independence protects decision-making. Decision-making produces lawful outcomes. Lawful outcomes reinforce the legitimacy of the system. In an administrative system like immigration court, the triad inverts. The purpose becomes policy execution. The mechanism is hierarchical control. The application is outcome alignment with administrative goals. Each part reinforces the others as well, but in the opposite direction. Control shapes decisions. Decisions reinforce policy. Policy justifies further control. That is why calls to protect judicial independence in this context miss the mark. Independence is not something you can restore through guidance, training, or better leadership. It must be built into the structure. If the same authority that benefits from a particular outcome also controls the people making the decision, independence is already compromised. No amount of professional norm setting can reliably counteract that. Consider how detention decisions work. In a neutral system, a judge evaluates whether a person poses a flight risk or a danger to the community based on specific facts. That is an individualized legal judgment. But if the system shifts toward discouraging release, whether through policy directives, supervisory scrutiny, or performance expectations, the default changes. Detention becomes more common, and detention itself creates pressure. People who might otherwise pursue valid claims begin to give up simply to avoid prolonged confinement. The outcome is shaped not just by law, but by the conditions imposed during the process. Again, this is not accidental. It is what happens when decision-making authority is embedded within a chain of command. The broader lesson here, honestly, isn't just some abstract warning about institutional design. It's actually much more direct and, well, a lot more uncomfortable. When you build a system like this, where the same authority that wants a particular outcome also employs, monitors, and removes the people deciding cases, you don't just get occasional corruption. What you get is a system that's built to be corrupted, and eventually it will be. And when pressure is applied from above, that corruption doesn't creep in slowly, it accelerates. Judges who try to apply the law neutrally suddenly find themselves at odds with the very system they serve. Their decisions get questioned, their performance is scrutinized, and their careers can become unstable. Some judges adjust, others leave, and some are actually removed. What remains isn't a balanced judiciary struggling to get things right. What remains is a body that's been calibrated to produce outcomes that align with the priorities of those in control. That is, in fact, exactly what a structurally compromised system does under stress. It doesn't resist pressure, it translates pressure into results. At that point, it is no longer accurate to describe what is happening as adjudication in any meaningful sense. The system still uses the language of courts, it still conducts hearings, it still issues decisions. But the function has changed. It is not determining what the law requires in individual cases. It is implementing policy through a process that mimics judicial form. That distinction matters because it exposes the central deception. The public is told that these are courts, that cases are being fairly decided, that outcomes reflect the application of law. But the structure ensures that outcomes will increasingly reflect something else, the priorities of the authority that controls the system. And once that is understood, the usual responses collapse. This is not a problem that can be solved by reminding judges of their duties. Many of them already know those duties and try to follow them. The system punishes them for it. This is not a problem that can be solved with better training, clearer guidance, or renewed commitment to professional norms. None of those change the underlying incentives. None of them remove the leverage that makes neutrality costly and compliance advantageous. Most importantly, this is not a system that can be reformed in the sense people typically mean. You cannot tweak procedures, adjust standards, or add oversight and expect the outcome to change in any durable way. As long as adjudicators remain inside a chain of command that has a stake in the results, the pressure will always be there, and the system will always bend toward it. The only honest conclusion is the one people are least willing to state plainly. A system built this way cannot reliably produce justice. It can only produce decisions that track power. If the goal is genuine adjudication, where individual cases are decided according to law without regard to political preference, then the structure itself has to change. The power to decide must be separated from the power that benefits from the decision. Without that separation, everything else is theatre. And until that happens, what will continue to exist is not a court system in any meaningful sense, but an administrative mechanism for carrying out policy, one that looks like a court just enough to make people believe it is one.